Hi everyone, I'm attorney Kyle Kaufman. This time we're going to talk about physical placement and what a court actually looks at in the law in Wisconsin to determine how to allocate physical placement. So let's jump into it. I thought it was, again, important to just sometimes go back to the law, right? We're lawyers here, and it's important to tell our clients and prospective clients what the law says about these issues. So Chapter 767 in Wisconsin is where we look for answers, and one of the sections there is on allocation of physical placement. And I want to read to you guys what it says there. It says that a court shall allocate periods of physical placement between the parties in accordance with this subsection, okay? So this gives us some guidance, right? It says a court shall consider each case on the basis of the factors set out in this statute. In a different video, I'm going to get into those factors and what they actually are. They're interesting. It goes on to say that the court shall set a placement schedule that allows the child to have regularly occurring, meaningful periods of physical placement with each parent that maximizes the amount of time that the child may spend with each parent, taking into account geographic separation and accommodations for different households. You'll notice there it doesn't say equal placement. It just says regularly occurring meaningful periods of physical placement with each parent, maximizing the amount of time that the child might spend with each parent, okay? It goes on to say a child is entitled to periods of physical placement with both parents unless, after a hearing, that the court finds that physical placement with a parent would endanger the child's physical, mental, or emotional health, okay? So that means that as a parent, you're going to have time with your child. However, if after a hearing, a court makes a determination that it would be harmful to the child's health, physical health or mental health, then that would be denied to you. The statutes go on to say that no court may deny periods of physical placement for failure to meet or grant periods of physical placement for meeting any financial obligation to the child or, if the parties were married, to the former spouse, okay? Interesting concept there. And sometimes you hear that, right? Maybe one parent is not paying child support and the other parent then feels they have the right to withhold placement to the non-paying parent, and that wouldn't be true under our laws here in Wisconsin. It also goes on to say, however, that if a parent is paying child support, it doesn't necessarily entitle them to any sort of specific placement schedule or any at all. Going on, if a court denies periods of physical placement under this section, the court shall give the parent that was denied periods of physical placement warnings about termination of parental rights, okay? So really serious stuff, and we're talking about those extraordinary cases, which, by the way, extraordinary is one of my favorite words if you really break it down. Extraordinary, right? Doesn't happen that often. So in the extraordinary circumstances that a court denies placement to a parent, then the court has to give termination of parental rights warnings to the parent to put them on notice that, hey, if this continues and persists, there could be a basis in the law to terminate your parental rights. All right, going on here. If the court grants periods of physical placement to more than one parent, the court may grant to either or both parents a reasonable amount of electronic communication at reasonable hours during the other parent's periods of physical placement with the child. And that's interesting, and as our world develops and our technology develops, electronic communication has really advanced. I mean, let's go back to the 1980s. If we were talking about, kids in non-intact families, we're talking about them getting on a telephone with the cord and talking to the other parent. That would have really been the only electronic way to communicate. Of course, now we have email and text messages and video capability, and it's just going to continue to advance. So the court can make an order that allows for electronic communication, which can be helpful and importantly to keep parents in contact with their children and increase that bond that they have together. So guys, that is what the Wisconsin laws say about allocation of physical placement. In the next video, I am going to talk about the specific factors that a court considers for custody and placement in determining how much time each parent should get with the child or what kind of custody each parent should have. We'll see you next time. Thank you.